I'm Jo Henderson. I'm a partner in the employment law team at Myerson. Following the implementation of the GDPR and Data Protection Act 2018 in May 2018, data protection issues are now at the forefront of business considerations, including HR policy and procedure. When the legislation first came into force, there was a flurry of activity, with businesses auditing their data protection practices and establishing appropriate new policies and procedures to ensure compliance with the new regime. However, from the outset, the Information Commissioner made it clear that the introduction of compliance measures should not be a one-off event, but the beginning of a journey of compliance. Ongoing audit and review of compliance measures is a crucial aspect of the accountability requirements of the legislation, especially against the backdrop of ever-advancing technology, information systems, and the use of AI. Here are my top 10 data protection tips for HR teams. Tip 1. Review privacy notices. A fundamental principle of data protection is transparency. Employers should have in place appropriate and accessible privacy notices for employees, workers, contractors, and job candidates. Privacy notices must clearly explain to individuals what personal data is held about them, how it is used, and why. With more sophisticated technology and information systems adopted by employers to achieve efficiency, for example, the use of AI in recruitment processes, privacy notices should be regularly reviewed to ensure that they remain current and accurate. Tip 2. Audit the categories of data collected. With ever-advancing solutions for collecting and storing data, it's easy to fall into the trap of collecting and storing personal data when there is no lawful basis for doing so. A common example is the use of technology to monitor employees, whether in relation to their presence in the workplace or their activities, especially when employees are working from home or using company devices or equipment. I recommend regular audit of what data is collected and retained with a view to identifying categories of data which the employer has no genuine or lawful reason to have. A common example I see is the request for diversity information when the employer does not in fact monitor diversity or otherwise use such data for a meaningful purpose. Tip 3. Understand the rules around criminal conviction data. Criminal conviction data is dealt with as a separate category of data under the data protection legislation. The rules overlap with other rules in relation to the rehabilitation of offenders and also specific rules in relation to sectors such as finance or care for children or vulnerable adults. As a result, the rules around criminal conviction data are complex. In a culture where meaningful employee references are rarely given and an economy where individuals may regularly change employer, I have seen an increasing trend of excessive employee vetting, often including the collection of criminal data through recruitment questionnaires or DBS checks. It is only lawful to collect and store criminal conviction data in limited circumstances where it is meaningful to do so for specific purposes arising out of the nature of the employer or the role being recruited to. Tip 4. Understand the rules around employee health data. Employee health data is treated as special category data for the purposes of data protection legislation. Employers are required to take care of their employees' health and well-being and are entitled to manage both performance and attendance, meaning that employers naturally have a legitimate interest in collecting and processing relevant personal data. However, such information is sensitive and misuse can give rise to serious breaches of the legislation. Further, in relation to employee health data, data protection legislation overlaps with other legislation in relation to medical records and medical reports, making this a complex area. I recommend developing specific policies to regulate the collection, use and retention of this special category of data so that it is used properly and in a regulated way, including by operational managers. Tip 5. Conduct annual employee data checks. One data protection principle is that the employee data held by employers must be accurate. I recommend that employers regularly and at least annually verify and update employee information to ensure that employee data is accurate and correct. Many automated HR systems will already have the means to facilitate annual checks, or they can be configured to facilitate such checks. Ensuring contact details, next of kin and emergency contact details are up to date is not only good practice but can avoid embarrassing disclosure breaches, which, in addition to being an instance of non-compliance, can seriously damage employee trust and confidence and potentially give rise to employment claims. Tip 6. Review data sharing arrangements. It's inevitable that employers are required to share employee data from time to time, for example, for the purposes of external payroll, providing benefits and obtaining occupational health advice. The Information Commissioner's Code of Practice on data sharing makes clear that data protection is not a block to sharing employee data. However, in the interests of transparency, employee privacy notices should be expressed about how and why employee data is shared with third parties. Further, it's for the employer to be satisfied that any sharing arrangement is secure. Terms and conditions with external providers must include appropriate terms in relation to the use, security and retention of employee data. Tip 7. Know how to deal with data subject access requests. A data subject access request is the most commonly exercised employee right, and we have all probably seen that it is often exercised in the context of a grievance or a dispute. I recommend having a documented process in place for responding to data subject access requests in an effective and timely manner. A response is usually required within a month of the request and may require considerable search for data and analysis of that data. Managers should be trained to recognise a data subject access request, and HR teams should clearly understand the ICO guidance on dealing with subject access requests. This is essential, as I have often seen responses which do not take proper account of the rights and privacy of other managers and employees in the business. Inappropriate disclosures can give rise to the escalation of disputes, employee relations issues, and non-compliance in relation to the rights of other individuals. Tip 8. Review security measures. No top 10 list of tips on data protection is complete without mention of data security. Ensuring the security of personal data is a fundamental requirement of the legislation, which affects every aspect of an employer's business. Breaches of security are the biggest risk in terms of non-compliance and liability for employers. Loss, damage or unauthorised disclosure of employee data can cause financial loss, risks to personal safety and distress. Essential security measures will include the use of access control, passwords, encryption and secure disposal. Security measures should be reviewed regularly against the background of ever more sophisticated cyber attacks and changing workplace cultures such as home working, working abroad, use of personal devices and hot desking. Additionally, having a breach response plan is an essential tool for HR teams. I recommend planning ahead so that in the event of a breach in relation to employee data, you are ready to issue employees guidance and assistance to help them protect their personal and financial safety. Tip 9. Use data protection impact assessments. On the introduction of any new HR system, initiative or new way of working involving employee data, I recommend HR teams use data protection impact assessments as a matter of good practice to assess data protection risks and identify the means to address those risks. There are certain circumstances in which the completion of a data protection impact assessment is compulsory, but that aside, such assessments are an especially useful tool and means of generating evidence that an employer has considered data protection compliance and the underlying requirement for accountability. The Information Commissioner's website includes useful templates and guidance on how to structure and complete a data protection impact assessment. Tip 10. Education and train managers and staff. Last but not least, education and training are a fundamental part of any compliance initiative. Specifically, all employees should receive training on the principles of data protection and particularly the security aspects of compliance. This is essential for the purposes of protecting an employer's business interests. Managers will require additional training so as to properly understand the principles underpinning the lawful use of personal data in the context of record keeping, recruitment, performance management, absence management, and in cases of ill health. Managers should also be trained to recognise data subject access requests and know how to respond to them promptly. If you need advice on data protection legislation and how it affects your HR policy and processes, then please get in touch. We are here to help. You can contact us on 0161 941 4000 or by email. Thank you for watching.